Good evening. My name is Joe Whitcomb, founder of Whitcomb Law PC, and I'm going to take the next 3 minutes and talk about the meritorious claim that you walked away from. Every year, federal contractors abandon meritorious bid protests because they misunderstand a single procedural deadline. The claim they wanted to file was sound, maybe the evaluation was flawed, or the agency applied unstated criteria, or they engaged in unequal treatment, or ignored their opponent's solicitation terms, and the contractor did not. Not because the merits were weak, but because the filing window closed while someone was still deciding whether to act. The Federal Circuit made the consequences of this kind of inaction explicit in Lillian Goldfield LP versus Impact States. The rule is unforgiving. A party that fails to challenge patent solicitation defects before the close of bidding waives their right to raise those objections later. This is not a discretionary dismissal. This is a jurisdictional law. First, you need to understand the architecture of protest and timeliness. The bar defines what constitutes a protest, defines who qualifies as an interested party, an actual or prospective bidder whose direct economic interest would be affected by the award or failure to award. Three forms exist: agency-level protest, protest to the Government Accountability Office, and actions at the Court of Federal Claims under the Tucker Act. The timeliness trap of the GAO is precise. Under 4 CFR 21.2, protests based on alleged improprieties in solicitation that are apparent before bid opening or the closing date for receipt of proposals must be filed before the closing date. All other protests must be filed within 10 days after the protester knew or should have known of the basis for protest. You miss that window by 1 day or a minute and the merits become irrelevant. Here the problem is not legal complexity, the problem is inaction. Contractors see the defect in the solicitation, recognize the unequal treatment in the evaluation, identify the unstated criteria, and they hesitate. They consult internally, they wait for a debriefing that comes too late, they assume the process will correct itself, and it simply doesn't. The consequence is permanent. The awaited protest cannot be resurrected. There is no equitable tolling at the Government Accountability Office. There's no second chance exists once the jurisdictional bar is missed. The meritorious claim that you walked away from stays dead. So you don't let procedural default destroy a substantive right. If you have lost a federal contract and something in the evaluation criteria felt wrong, act now, not next week. At Whitcomb Law PC, we offer a free case review to determine whether your claim is timely, whether it has merit, and which form gives you the strongest posture. You can call me directly at 303-573-5461, or you can visit my website at whitcomballpc.com. Don't miss a demo. If you thought this video was useful, please like, share, and follow. Again, my name is Joe Whitcomb, founder of Whitcomb Law PC.